I want to begin by acknowledging the patron of this lecture series, Professor DeLloyd Guth, who I understand is on the call right now. We're very grateful to him for... Hi, DeLloyd.
Hi, hello everyone.
Hi. We're very grateful to him for...
I'm at long distance from Ann Arbor, Michigan.
Okay, so to my point about joining from across the miles.
I'm socially distant, but intellectually engaged and eager.
Excellent. So we're very grateful to DeLloyd for sponsoring this lecture series. Now, this is the 12th lecture in the series. And today we are honored to have as our speaker, Professor Nicole O'Byrne, who is an associate professor at the Faculty of Law, University of New Brunswick in Fredericton. She teaches Indigenous and non-Indigenous relations, as well as federalism, self-government, evidence, and criminal law. She has an LLB from the University of Saskatchewan, an LLM from McGill, and a PhD in law and society from the University of Victoria. So spanning the breadth of Canada. Her research examines the history of federalism in Canada, including the policy history of Medicare and Métis-state relations. She has served as the Vice President of the Canadian Association of Law Teachers and is the current past President of the Canadian Law and Society Association. She is a frequent media commentator on constitutional issues, including governance, treaty rights, and criminal law. And so with that, I will turn the mic, so to speak, over to Nicole.
Thanks, Virginia. What a thrill it is, and how wonderful it is here to hear Professor Guth's voice, even at a distance. I just was thrilled to receive this invitation. I've done my best to put something together that'll be 40 minutes or so. Please feel free to cut me off at 40 minutes. This is research I've been working on for about 15 years or so now. So once I get started on this, I could go for about 3 days. So I'm going to do my best. I put together a slide deck to kind of keep me hopefully reined in. It's going to be mostly a Canadian history lesson today. And from, of course, the shores of the St. John River, the Wolastoq River. This is a mural that we have up at the University of New Brunswick called Teachings Along the River. So from our river to the Forks in Winnipeg, we're connecting here at a distance, but I just absolutely love any opportunity to interact with my colleagues and friends at the Faculty of Law, University of Manitoba. What a wonderful group of people you are, and I'm just thrilled to be here. So let's get into this. First of all, big thank you to Professor Guth. About 10 years ago, he read my master's thesis. He did a full correction on this 200-page, very, very lengthy thing. I'm still working through the implications of what he pointed out to me, and I basically had to write a dissertation in answer to him. So Professor Guth, I'm still working on it. That book is going to come, I promise you. But thank you so much for giving me so much support and encouragement at a time when I really needed it, because I was really doubting whether or not this project had legs, and you really gave me the boost that I needed. So with that, let me try to show you what I've done since you've read this thesis. First of all, when it comes to the natural resources transfer agreements, which I'm going to be talking about today, I want to tell a little anecdote. Stuckhedge Henderson, professor at the University of Saskatchewan, a mentor to so many of us, especially non-Indigenous people who generally are pretty new to a lot of these issues, or very unfamiliar and wary about how we could even approach some of them. I went up to him after a guest lecture when I was in first year law school, and I said, this is really interesting. I have a degree in Canadian history. I know almost nothing about the natural resources transfer agreements or Métis Scrip or treaty rights or any of these things. What should I be reading? And he says, well, when it comes to the NRTAs, you're going to have to do it. Okay. It's pretty dangerous to say that to a first year law student. I took him seriously, and I've been working on the NRTAs basically ever since. It was almost 20 years ago. I'd like to thank him. Here's his recent book, this little advertisement. It is a work of a lifetime, so I encourage you to take a look at the Wabanaki Compact. Has to do with the treaties in the Maritimes and the fact that we're on unceded territory. Another mentor of mine, Dr. Jim Miller at the University of Saskatchewan, wrote an article in the 1980s called From Riel to the Métis. And I know this is a provocative thing to say to a group of people in Manitoba, but there were a lot of Métis outside of Manitoba. And what I take from his article and from his mentorship is that you can often learn more about the Métis in Manitoba from external sources. So that's what I've been doing. I've been looking at the debates over Métis Scrip from the perspective of Saskatchewan and Alberta to shed some light on what happened at Red River Settlement, et cetera, et cetera. So it's a different perspective. So you're not going to hear a whole lot about Manitoba directly today. You're going to hear about Manitoba indirectly through what happened at the same time, or basically the same time, in Saskatchewan and Alberta. And there's a lot of different source material that no one had ever looked at with respect to the context of Métis Scrip and all the land question in Manitoba. Okay, so this all goes back, of course, to Lord Durham, nicknamed Radical Jack, who was, of course, given the task of how do we create a country out of these colonies in Canada. So he wrote the infamous Lord Durham report, in which it says, with respect to public lands, that that's the essence of self-government, right? Any kind of self-governing territory has to have control. The government has to have control over the public domain. The general revenue from that public domain then goes into creating and implementing public policy that reflects the needs of the people being governed in that territory. That is the essence of self-government, okay? And Section 109 of the British North America Act brings in this idea, it imports this idea into the Constitution. You have to own land, territorial sovereignty, the revenue derived therefrom, all goes together. And of course, Louis Riel was familiar with that. He had legal training. He knew all about Lord Durham's report. And when he was the leader of the provisional government at Red River Settlement, he sent in a list of demands, or the provisional government did, saying that they have to have full control over the public domain and the natural resources of Manitoba in order to create and deliver and implement public policy that reflects the needs of the people being governed in that territory, okay? Straight out of Lord Durham's handbook. But that's essentially what self-government means. Now, there was a big dispute between Manitoba entering Confederation. Should it be a province or a territory? The difference is that territories do not control the revenue derived from the public domain. Okay, that is managed and administered by another level of government. So Louis Riel really wanted to make sure Manitoba was a province and had that full governing capacity to reflect the needs of the people that are being governed. Okay, that's what self-government is, my friends. And there's the ghost of Lord Durham looking over at Louis Riel. And I guess the villain of the piece is our friend John A. Macdonald. When you're trying to implement the national policy, which is a coordinated immigration, railway, and homestead policy to settle the West, the last thing you really need to do is turn over the land to a provincial government that's autonomous, that you don't control. So when it came to Manitoba entering Confederation, John A. Macdonald says, well, we can call them a province, but we're going to manage the land and resources from the Minister of the Interior in Ottawa and maintain control. And when Alberta and Saskatchewan were created in 1905, the federal government found that that was so expedient and good for implementing their policy that that was put in place as well. So you have the three prairie provinces not constitutionally equal to other provinces in the country. And that's very relevant background for when we talk about the purpose of the natural resources transfer agreements. And that's what we're talking about, governance, okay? Again, I might be sounding repetitious here, but this is what I have to get across to you before we go forward, is that government means control over the public domain, the general revenue derived therefrom, to implement policy that reflects the cultural linguistic needs of the people in that territory. Manitoba, those of you in Manitoba, I'm sure you've heard this before, became the Cinderella of Confederation because it was a province, but only in name. The resources, the revenue were kept in Ottawa, and what Manitoba got every year was a subsidy in lieu. And that's the essence of the conflict when it comes to Manitoba. Is it a treaty, right? Was it an agreement? Well, arguably, Georgette Chancartier and John A. Macdonald outmaneuvered the Métis negotiators, and Manitoba comes in as a province in name only, okay? Still lots of disputes about the meaning of the Manitoba Act, and I encourage you to read this recent book by Larry Chartrand. And here's another book I highly recommend by Jim Machorik. He's at the University of North Dakota. He talks about how Manitoba grappled with this natural resources question and their constitutional inequality from 1870 to 1930. It's a gripping story. Of course, Louis Riel does not stay the leader of the provisional government at Red River, but he moves west, and the Canadian government asserts sovereignty. So by 1885, you have a very different situation than you had in 1869 when Manitoba was a separate crown colony or Red River settlement, okay? So what happens in Saskatchewan, of course, is now the rebellion, okay, the Northwest Rebellion, and the trial and execution of Louis Riel. But his legacy lives on, and he wrote that his people may sleep for 100 years, but it'll be the artists that give them their voice back. Well, maybe I'm a law professor and I'm a little biased on this, but the lawyers have also given the Métis people their voice back with a series of litigation, constant agency and advocacy, all the way from 1885 to present day. This isn't a story of people being silenced. This is a story about people asserting their rights, finding ways to bring their voice to the table when all odds were against them. That's some of the story I'm going to tell you today. Now, Manitoba, Saskatchewan, Alberta are in that anomalous constitutional position. And the governments from Louis Riel, when he was the leader of the provisional government at Red River, right up until 1930, every premier of every political stripe in all three provinces thought that the deal that they had been given in Confederation, entering Canada, was a bad one, okay? They didn't have the ability to govern the territory the way that they wanted to. Ottawa was still making all the decisions. Ottawa was alienating land to the Hudson Bay Company, to railway companies, to homesteaders, to third parties, and the local provincial governments didn't have a whole lot of say, okay? That was a real sore point in federal provincial relations. And it's the root of Western alienation. When you hear Alberta still complaining on a daily basis about what Ottawa is doing to them, that's because their resources were owned by Ottawa and managed by another level of government till 1930. And those ideas still resonate in the West, okay? So now what happens in the late 19th century is the federal government sets up what they call Scrip commissions. So if you're a Métis person and you want your land entitlement pursuant to the Manitoba Act, it also goes further west. You have to bring your claim, it's adjudicated, and then you get maybe some land scrip or Métis scrip, which you might use to go farming, or you might assign it over and get cash instead. It's a hard thing to understand what a scrip is with respect to being a legal instrument. So one of my Métis students says, don't worry, Professor O'Byrne, it's just like Canadian Tire money, okay? So it's redeemable, but only for a certain purpose, okay? So we have what they call money scrip, and this is land scrip. So Métis people would get these certificates, then go to the Dominion Lands Office, and then get land that they could use to then go farming, okay? But a lot of Métis do not have the wherewithal for the investment to go farming, okay? It's one thing to get land, it's another thing to have the equipment, the machinery, the know-how, or even the desire, okay? So a lot of Métis do not take up scrip with respect to farming. They flip it over into cash. They move further west, and Métis scrip gets so complicated. There's so many fraudulent practices surrounding this. But the upshot is a lot of Métis do not get their land entitlements. There's been a ton of litigation the last few years about this. They move west, where they hunt and fish and trap. Okay, so here's some of the what they call road allowance communities. So they're not living on surveyed land. They're not homesteading, which would have been their entitlement under Scrip. Some are, okay, but a lot of them are moving further north and pursuing a more traditional livelihood. And the conditions are not great, okay? They're not on Indian reserves, okay? But they're also not homesteading, and they're not given the entitlements that other citizens are given for granted. And it's a very desperate living situation for a lot of Métis as we head into the 1930s and the natural resources transfer agreements. So here's Arthur Meehan. Of course, we've got provincial premiers for decades going to Ottawa, complaining about the bad deal that they've got in Confederation. And Arthur Meehan gets up in the House of Commons and says the following: "It's not a hard matter to scramble an egg, but it's a very hard matter to unscramble it." Okay, so what had been happening, of course, is Ottawa retained control over the public domain and the natural resources, did what they wanted with it for decades, and now the provinces want to have that control, and they have to somehow try to unscramble the scrambled egg and move that decision making from one level of government to another. And this is where the NRTAs get really interesting for me, which is why I've been kind of obsessed with them for 20 years, is that when Aboriginal people, Indigenous people, Métis people talk about self-government, everyone raises their hands and says, well, we don't know what they're talking about. Oh, we do know what they're talking about. We're talking about the transfer of decision-making authority from one level of government to the other. Well, we did it with the Natural Resources Transfer Agreements 1930, when we moved that public domain, the control and administration of the public domain, the three prairie provinces, we moved it from Ottawa to the three prairie provinces. So don't tell me that we can't do it again with respect to the transfer of real decision-making control to First Nations and Métis governments. We already actually have a model on how to do it. And here's what's at stake, right? So here's the premiers going off, the modern pilgrims to Ottawa pleading their case, saying we need control over the resources. Here's on the left-hand side, you'll see a cartoon that kind of shows how much money is at stake. And this is money from, the 1920s, so almost 100 years ago. And the settler governments are so concerned about this fiscal imbalance and the lack of decision-making authority, they're not really thinking about Indigenous people or Métis people. They themselves think that we are a colony of Ottawa. And people who generally think of themselves as being colonized don't tend to think of themselves as colonizers. But the Métis who are living in the Road Allowance, the Métis who have been subject to a fraudulent Scrip program, certainly have a different view of this. And so does our friend Duncan Campbell Scott, okay? One of the more controversial and infamous figures in Canadian history, of course, one of the architects of the residential school system. He's reading an Ottawa newspaper some morning, 1922, and it says they're going to start negotiating the NRTAs again, and that transfer from Ottawa to the Prairie Provinces. And he says, you can't do it without me. We haven't set aside all our treaty land yet, okay? And there's a whole bunch of other issues that come up with respect to his wards, okay? That's the language of the day, right? So he gets in there, and the NRTAs do deal with treaty rights, hunting rights, and then Métis Scrip is another outstanding obligation to Métis people gets put in the mix as well. And that's what we get, the British North America Act 1930, otherwise known as the Natural Resources Transfer Agreements. Took decades to negotiate, and they signed it here at Laurier House in Ottawa. I'll point out the date, 14th of December, 1929, because the 13th was a Friday, and our dear Mackenzie King was a very superstitious person, and there was no way he was going to sign this agreement on a Friday the 13th. So they get signed on the 14th. He's a quirky guy. Okay. Well, you can't really unscramble scrambled eggs, though, can you? Right? One level of government has navigated and governed these resources for decades. How do we transfer that authority over? Well, my friends, you do the most Canadian of things. You have a series of royal commissions, and that's what they do, okay? There's 3 royal commissions struck, one to deal with the transfer to the government of Manitoba, and then subsequently to Saskatchewan and Alberta. And that's in the context in which the obligations with respect to Métis-scrip are engaged and debated. Okay, so at the Natural Resources Commissions, the federal government argues that the obligation for Métis-scrip passed with the signing of the NRTAs as either trusts or contractual arrangements. But the prairie provinces push back on that and say, look, federal government, you've already alienated most of our arable land to homesteaders, to the railway companies, to Hudson Bay Company. There's almost nothing left for us to govern, okay, especially in the southern regions of the province. So we're not going to give out 1 more acre of land to some outstanding federal obligation that was full of fraudulent practice as well. So we do not want to take this over. So there's a huge fight at the Natural Resources Commissions about who's responsible for all the outstanding Métis-scrip. Now, it's not even debated in Manitoba. They're so worried about forestry and water and you name the natural resources issues that Métis-scrip just kind of gets lost, okay? It's just interesting. And of course, there's my Canadian Tire money. Back and forth between the federal government and the provincial government. Gotta love Canadian federalism. By the time we get to the Saskatchewan Commission in 1934, however, okay, and James McGregor Stewart, and those of you who are watching from the Maritimes are, I'm sure, aware of the law firm Stewart McKelvey. Well, he's the Stewart and Stewart McKelvey, that big law firm, okay? He's a very able lawyer, okay? And he argues on behalf of the federal government. And he says the purpose of the NRTAs are to establish constitutional equality between all provinces in Canada. But that includes the 3 prairie provinces taking on all outstanding federal obligations, including Métis-scrip. And he says, once you sign on, and they did sign on the 14th of December, 1929, once the provinces signed on, they agreed to take on the obligations that the federal government had yet to live up to. And that included setting aside more treaty land, reserve land, and the outstanding Métis-scrip. Now, Percival Gordon is the lawyer at the Saskatchewan Commission. And he says it's really unfair. I mean, Scrip was full of fraud. It was a problematic program designed by the federal government to defraud the Métis people and then take even more land away from the provincial government. So he fights tooth and nail against taking on that obligation. He claims it's widespread knowledge that the Métis were defrauded and that they were given trinkets in exchange for their land. During his retirement, though, he spent a lot of time opposing the commemoration of Louis Riel, calling him a bloody murderer. So I'm not sure there's just constitutional arguments in mind here. I think there's a good dose of prejudice and racism as well. And then we get to the Alberta Commission. James McGregor Stewart is again the lawyer for the federal government. And here's where things get really interesting, especially for you Manitoba folks, okay? He says Métis, from the perspective of the federal government, have always been considered Indians pursuant to 9124, the British North America Act, 1867. Well, that's startling, right? Because of course the federal government has always denied that Métis people should be given treaty or should be considered as Indians under the Indian Act. And he says, no, they had to have some kind of jurisdictional authority to issue Métis-scrip. And so the federal government said, for the purposes of scrip, Métis fit under the category of Indians. Now, those of you who are familiar with the Daniels case, which is fairly recent, that took decades to come to the same conclusion, might find it interesting that decades earlier, 80, 90 years earlier, the federal government's position at this Royal Commission were Métis are Indians for the purposes of issuing scrip, okay? Interesting. Now, what's happening while everybody's wrangling at these natural resources Royal Commissions is that the Métis are getting organized. So there's two gentlemen in Alberta who are especially notable, Jim Brady and Malcolm Norris. They decide, look, we're worried that the transfer from the federal government to the provincial government means that our claims to title, our current, and a lot of Métis were living on Federal Park area, okay? They were worried that they were going to get displaced by land-hungry provincial governments, okay? So they start lobbying the government of Alberta to say, hey, we've been here for decades now. You need to recognize our title. We do not want to be displaced. So they get together, they lobby, and their lobbying of the United Farmers of Alberta government brings about a Royal Commission in Canadian style, okay? So the Ewing Commission, look at that politically incorrect language, okay? It's a report on the Royal Commission on the condition of the half-breed population. But yet, this is a commission that looks at the socioeconomic position of the Métis in Alberta and comes up with some recommendations about what should happen in the context of the failed Scrip program and in the context of the transfer of resources from Ottawa to Edmonton. Through this, the Métis have two very effective advocates, okay? So Jim Brady, during this commission, says the following: the present misery, the Great Depression, is a result of that shameful episode of the forward march of capitalism on the prairies, and Métis Scrip is part of that. Land, homestead, immigration, railways are all part of that. And he says constitutional principles in the abstract don't help. We need to talk about tangible relief for Métis, which means land, okay? And he says, we have no other weapon except organization. And so they organize and they lobby and they make effective arguments. So what happens? They argue that land in Alberta should be given to the Métis in recognition of the failures of the Scrip program, which were widely known and admitted at the Natural Resources, the Dysart Commission. And they say the history of the Métis is really the history of the attempts to defend their constitutional rights against encroachment of nascent monopoly capital. So Jim Brady and Malcolm Norris are definitely on the left side of the spectrum, where a lot of people were during the Great Depression. And they were looking to land to redress some of the issues their people were experiencing. So here's what happens in Alberta. You get the Alberta Métis land settlements, because the Métis and Alberta both see land as a solution. One, Alberta has gone bankrupt in the 1930s, so they don't have any money to spread around, but they do have land to allocate. So they do that, and the Métis end up with land settlements. So Alberta sees land as a cheap way to distribute relief, which we now call welfare, and the Métis see it as a historical redress for a failed Scrip program. So they talk about having shared governance of these land settlements. And at first, that's how it works until it doesn't, okay? With the election of Bible Bill Aberhart, okay? They don't like this whole arrangement that has been figured out by the United Farmers government. They shift gears completely. They pass a couple of pieces of legislation that take those Métis land settlements and try to turn them into Indian reserves where they control what happens, okay? So they eliminate the Métis Association of Alberta's governance role in the settlements. They now follow a reserve model where they bring in supervisors, vocational education, and they say to the Métis, this is the only kind of help you're going to get. So unless you move on to these settlements, you're not going to get any help from the government with respect to redress for the Métis Scrip program or the socioeconomic problems you're experiencing during the Great Depression. Meanwhile, in Saskatchewan, okay, you get the Saskatchewan Métis Society forming in 1937 with the same idea as the MAA in Alberta to lobby on behalf of Métis interests. But they're a lot more closely tied to the Liberal Party in Saskatchewan. That's going to matter. Hang on. One of the MLAs stands up in the Saskatchewan Legislative Assembly and says the following. Okay, I'll let you read that quote. And he argues that the federal government needs to be held account for the fraudulent practices associated with the Métis-scrip program. And he says the Scrip program was like a bone being thrown to a dog, that the federal government never meant to live up to it anyway, but that something needs to be done. He calls for a full inquiry in Saskatchewan. Now, we got to flip back to what's happening at these Royal Commissions on the NRTAs, okay? James McGregor Stewart, of course, is making arguments that Métis have always been considered Indians under 9124, and that Métis were legally considered Indians for the purpose of issuing scrip. Now, Saskatchewan refuses to fulfill outstanding obligations to Métis arising out of the failed federal program. They just refuse, okay? But what they do is they give money to the Métis in Saskatchewan to pursue their claims in court against the federal government, okay? So it becomes part of the fight between Saskatchewan and Ottawa on the unscrambling the scrambled eggs, okay? So they fund this legal opinion. And this is quite an infamous legal opinion from a law firm called Hodges and Noonan. And what they decide in this legal opinion is the following: that Métis claims are not legally enforceable, okay? They're only moral and equitable. This is prior to 1982, right? So what can you do in proceedings versus the Crown? It's very, very limited. So they say the Métis claims are all political. And that meant no legal recourse could be undertaken to redress the failed Métis-scrip program, that this all had to be through the political sphere. So this rights-based strategy fails absolutely, and you do not get land settlements in Saskatchewan like we do in Alberta. But Saskatchewan, always a place of innovative public policy, home of Medicare, that's where I'm from, so I like to brag about it. They experiment, okay? They set up the Northern Saskatchewan Conservation Board because they realize scrip has failed, the people need what they need, okay? This is absolute crisis. We're gonna have to just move away from this fight over constitutional rights and history and failed Métis-scrip program and actually look at the needs of the people and come up with something new. So they do, okay? So what they create is a federal provincial cost sharing program designed to boost game, fur, and timber resources for, quote, northern residents, which of course means Métis and non-status, okay? The province is going to deal with the operating costs, the federal government's going to put in capital costs, and then Hitler invades Poland and the feds pull out and say we got other priorities, so they take all their money. So the province is left on its own, okay? And they do a few things, but it's limited. What they also do is they follow the Alberta model and they set up a land settlement, okay? But in Saskatchewan, there's no administrative framework or no legislative framework. It's an administrative experiment, okay? It's loosely modeled on Indian reserves, and the goal is economic self-sufficiency, the supposed goal we see with the Indian reserve system as well, okay? Catholic Church, again, is brought in to provide nursing and teaching services, and then to focus on a skills-based education. So in the context of Indian reserves, very, very similar setup and delivery. Now, our friends from Alberta are tired of dealing with Bible Bill Aberhart. Tommy Douglas, the premier of the CCF government, hires them to move north and work on economic development programs specifically designed to deal with Indigenous people in northern Saskatchewan. They are integral to setting up co-ops, Saskatchewan Fur Marketing Service, the Fish Board, Timber Board, and they look at it as good socialists would, is that this isn't an issue of race, this is an issue of economic development. And once people have equal access to decent income, all the other problems will kind of unwind and solve themselves. Is a contested legacy with respect to the CCF and their Indigenous policy. So here we go. How am I doing for time? Oh, pretty good. Okay. So I've been a little misleading in the title of my talk. The constitutional responsibility for Métis-scrip should have had a question mark. Because of course, no one takes responsibility for Métis-scrip. The Métis fall through the cracks of Canadian federalism. And what you get is debates at natural resources, Royal Commissions. You get other commissions trying to figure out what we should be doing. You get public policy experimentation, but you never ever get a recognition or an acceptance of responsibility for the failures of the Métis-scrip program. What you get are provincial and federal governments saying it's not our problem. And then everyone has to deal with what flows out from that. So the constitutional responsibility for Métis-scrip, maybe it still exists, but I think it shouldn't be left to the dustbin of history. I think this story shows some of the opportunities we have to revisit these issues and to see, I hope, how much we're still having the same debates, right? Who's the responsibility of whom? How do we actually devolve meaningful self-government? And I'm a legal historian, and I'm pretty sure Professor Guth will back me up on this. We can learn a lot about the present when we study the past. So hopefully I've given you a bit of a history lesson here today, and feel free to ask me any questions. Thanks for listening. It's been a real thrill to talk about my research.
Thank you so much, Nicole. I think we can go around with a virtual applause.